Good morning. I hope everyone's doing well and survived the Super Bowl, or the lack thereof, for Cincinnati. We have 6 cases on the docket this morning. 3 have submitted on the briefs. 3 is scheduled to argue this morning. I will be calling out all the cases. The first case that we have is case number C220323. And I don't know if it's TILR Corporation versus Talent Now. If attorneys can please identify themselves and their readiness to proceed.
Your Honor, on behalf of the appellant, Talent Now, and More Ventures, David Hine, Jordan Steiner, and the architect.
Thank you.
Good morning, Your Honor. Scott McIntyre on behalf of plaintiff, I believe, Tiller. I have Sean Huffman.
Okay, so it's Tiller. Thank you. And then we have case number C220386, Young versus UC Health.
Scott Thomas for appellant, Your Honor. We're ready to proceed.
Thank you.
Your Honor, Allison Kunner here on behalf of appellee, and we're ready to proceed as well, and with Mary Jo Coleman as well.
All righty. And you'll be the only one arguing?
Yes.
Attorney Kunner? Okay. Next is case C220284, State of Ohio versus Arnold.
I didn't understand that.
Good morning, Your Honor. Krista Giesky on behalf of Hassan Arnold, ready to proceed.
Thank you.
Danielle Ferris on behalf of the city of Cincinnati, ready.
Thank you. And whoever phone that is, you're probably best off turning it off. Case number C220181, State of Ohio versus Johnson, has submitted on the briefs. Case number 220190, State of Ohio versus Banner, also submitted on the briefs. And case number C220145, State of Ohio versus Abdallah, also submitted on the briefs. So Tiller Corporations versus Talent Now, whenever you're ready, you can come forward. You can come to the podium. Good morning.
Good morning.
Would you like to reserve time?
Yes, Your Honor. I'd like to reserve 5 minutes.
All right, whenever you're ready.
Thank you, Your Honor. Good morning. May it please the Court. There are 3 assignments of error in this case, but because the Court's disposition of the first has the potential to obviate any consideration of the second and the third, I'd like to focus on that first assignment, which pertains to the trial court's denial of my client's motion to dismiss. Now, the central question posed to this Court is whether the appellee Tiller is entitled to pre-suit discovery in this case, either under the statute, Section 231748 of the Ohio Revised Code, which permits pre-suit interrogatories in certain instances, or under the Rule 34D, which permits pre-suit requests for production in certain circumstances.
And if they're entitled to it under one but not the other, would it still result in the denial of the motion to dismiss?
If the Court determines that they are entitled to discovery under one mechanism but not the other, I believe it would result in a partial denial, but a partial grant as well, because they are independent mechanisms, Your Honor. Now, the answer to the question, I believe, with respect, and notwithstanding what the trial court said, is no. And that is advised or informed by a reading of literally all of the law in Ohio. What the trial court found expressly in its February 28, 2022 entry was that Tiller was trying to use pre-suit discovery in order to determine whether or not it had a cause of action. That is not permitted under either of the mechanisms. Now, the Court invoked Rule 34D and what I believe is a misapplication of 34D, but was silent as to the statute and interrogatories. So I'll address the statute first. In order to affirm the trial court's ruling and overrule our first assignment of error, the Court needs to ignore the express language of the statute, ignore binding precedent from the Supreme Court of Ohio in Palos, which the trial court did not grapple with, and ignore this Court's own precedent in Colgate, a court that Tiller has never acknowledged.
Where's the language in the statute that limits it? Where's this language in the statute that limits it to simply the identification of a potential party?
Your Honor, for interrogatories, it is not limited to the identification of a potential party.
Okay.
For interrogatories, it is limited to information, and this is expressed by, particularly articulated by the Supreme Court of Ohio. Pre-suit interrogatories must be served on the party that you intend to sue for the specific purpose of identifying a fact that you need in order to finalize an already articulated and cogent cause of action. You cannot use interrogatories in order to determine whether you have a cause of action. That is the fishing expedition that Paulos said is not permitted.
Well, I think part of the issue here is it seems to me that as I look at these interrogatories, some of them, even under your articulation, seem like they would be partially permissible, but maybe partially overly broad. And like that's not the argument that I see you making in the brief in terms of the distinction between the two. It's just a kind of all or nothing, like they violated the statute, they went afoul of the statute. Some of this stuff, I mean, a list of customers that the person worked with, I mean, that would seem to be permissible.
Well, Your Honor, a list of customers, I think the question that the court needs to ask is whether or not they need to know which customers the employee worked with in order to
Presumably
articulate.
they would if they're claiming that she took their information and misappropriated it to do bad things with other customers. Knowing who those customers are would flesh out what the cause of action is.
It would certainly help them prove the cause of action, Your Honor, but I don't believe that information is necessary in order to articulate the cause of action, and that is the distinction that Paulos made. But the reality is, Your Honor, you're touching on a point, and we're kind of jumping ahead to the second assignment of error here, which is that even if the court determines that Tiller is entitled to pre-suit discovery, the court still has to engage in the further analysis to determine whether the actual requests fit within the narrow confines of pre-suit discovery, which the trial court below never did, and Tiller refuses to do, because I believe that the requests do not fit within that. For example, they also ask, Your Honor, Your Honor, a list of customers, and not just our customers, but our prospective customers, and not just the customers that they work with, but that she had access to, that's presumptively a trade secret in Ohio. So what they are saying is that because they believe that their employee absconded with proprietary information, our client in a pre-suit context should have to turn over its proprietary information, which is not what the rules indicate. I want to circle back to Rule 34D real quick, though, because the interrogatories only represent half of the case, and under Rule 34D, it is limited in the language of the rule to identifying a party that is known to be adverse, but that can't be identified, that can't be ascertained. The example that the rules and the staff notes invoke is a products liability case, where you know that somebody manufactured a defective product, but you don't know who the manufacturer was. So you serve request for production on a non-party in order to identify who that adverse party is. The trial court found that Rule 34D can be used beyond that in order to determine whether or not a party has a cause of action. But
And leaving that aside for a second, and again, this goes back to my parsing of these requests, but when they seek to identify and or any other related entity that she had contact with or that got the information that she allegedly stole from them, that to me seems like identification of a party, because there's a corporate structure here that I don't fully understand, like what the permutations are. It sounds like they don't either, and they don't know if some subsidiary or affiliate got this information and did bad things with it.
And that precisely is the point, Your Honor. They don't know, and that's what 34D is not permitted to do. See, what the court found is that Tiller is trying to identify who, if anyone, those are the court's words, encouraged their former employee to abscond with information. That if anyone connotes what the reality of this case is. Tiller is speculating. They don't actually have any idea whether that person exists. And if the answer to the question is no one, then they do not fit within the confines of Rule 34D. Similarly, they want to know who, if anyone, Ms. Crenshaw gave that information to, and what, if anything, that hypothetical third party did with the information. But the answers to those questions, likewise, could be nothing and nobody. And Tiller acknowledges that, which puts them outside the scope of Rule 34D. And in order for the court to affirm the trial court's ruling, this court, in assessing the scope of 34D for the first time, needs to cut against 7 sister districts.
Let me interrupt you for a second. In the Wheeler case, didn't this court discuss the scope of 34D?
Your Honor, the Wheeler case actually pertained to pre-suit interrogatories. And in its discussion, in what I believe is dicta, the court was analyzing the distinctions between the two mechanisms. The statute, 231748, which the court indicated its analysis was predicated on, and 34D. And in Wheeler, the court did cite what was, at the time, the only appellate court in Ohio that had addressed the scope of 34D. That's Benner. And in Benner, the 6th District did say that Rule 34D can be used to determine whether or not a party has a cause of action. What that was based on, we have no idea, because there was no citation, no explanation, no analysis at all. And what the court needs to understand is that in the 25-plus years that have elapsed since that point, again, 7 other appellate courts have addressed this question and found Benner to be bad law. The 2nd, 3rd, 8th, 9th, 10th, 11th, and 12th districts have all determined that 34D cannot be used to determine whether or not a party has a cause of action, and that it must be limited to identifying a known adverse party. 3 of those courts, the 2nd, 10th, and 11th, called Benner out by name and said, that is bad law. You can't follow that. And even the 6th District, which issued Benner in 2002, so 5 years after Benner was issued, issued another decision, Smith v. Baumgartner, which is 2002, Ohio 232, and quietly walked away from Benner. They didn't mention it. They didn't cite the case. But the facts of Smith and the facts of Benner are virtually indistinguishable. And in Smith, the subsequent case, the 6th District expressly held that you cannot use pre-suit discovery in order to determine whether or not you have a cause of action, which means that the express holding of the trial court in this case is at odds with virtually every appellate district that has reviewed the scope of pre-suit discovery in Ohio. And for this court to affirm it, the 1st District needs to strike out on its own and take a position that is at odds with every district that has addressed this question. I don't think I need to say it, but I will. The court should not do that. And if the court does do it, we would ask that the court certify its decision for a conflict, because we believe the Supreme Court of Ohio would need to address that, because it's not appropriate for parties to be subjected to different standards depending on the jurisdiction that they happen to be in.
Counselor, you have about a minute left.
Thank you, Your Honor. Before I sit down, if I may be so bold, I would like to propose a few questions for the court to ask Tiller, because these are things that have never been addressed. Under either of these standards, either of the mechanisms, the party needs to identify the cause of action that they think that they have. They need to identify the fact that they don't have, that they think that they need in order to articulate a claim, and they need to explain why the particular requests they have propounded actually address that fact and get them to that fact. They have never done that, ever. And I think it's important that this court hears that. Thank you very much.
Thank you.
May it please the court. Your Honors, thank you for your time. This case is not precedent-breaking or groundbreaking, as my opposing counsel would suggest. In order for your court, notice the abuse of discretion standard was never mentioned. In order for this honorable court to overturn Judge Hathaway, this court would have to find that she abused her discretion. That's essentially...
I'm going to stop you right there.
Yes, Your Honor.
Okay, so the Wheeler case, it refers to testing the sufficiency of the complaint, and it appeared to give no deference whatsoever to the trial court's findings. I'm struggling to see how on a 12b-6 it would be an abuse of discretion. I understand that this is about discovery, but it is still a 12b-6.
Well, this is a...
And I'm talking specifically on the motion to dismiss, not on the motion to compel or the protective order.
Yes. Well, on the motion to dismiss, I would state as an initial matter, the court holds in Wheeler that discovery should proceed and the trial court enjoys broad discretion concerning the discovery issues. And I would submit that we have an abuse of discretion standard, the vast majority. In the briefing in this case, Your Honor, there may be one case that's cited that involves a de novo standard. But I submit that Wheeler...
But you have to show that legally you are entitled to serve pre-suit discovery. And to me, that threshold issue is an issue of law. And then the question of the proper scope is probably an abuse of discretion on a motion to compel. But in terms of filing the complaint, getting in the courthouse door here, that has to be an issue of law.
Well, it's all bound together for this appeal, Your Honor, and I would submit that the motion to dismiss, there's no jurisdiction also on the motion to dismiss issue, and we had filed a motion to say that there's no jurisdiction on that issue, and that was never ruled upon. So our argument is that the 30-day rule applied, and the 30-day rule to appeal on a motion to dismiss was expired by the time this appeal happened. And so we would submit that there's no jurisdiction to look at the motion to dismiss, and this essentially went into the discovery issue, which is, there's no dispute, it's abuse of discretion. And I have not seen in the reply, there's no mention of the motion to dismiss. So the majority of this appeal, at least on the briefs, concerns the discovery issue in terms of the motion to compel, motion for protection.
Let me ask you this, going back to a question I asked Mr. Hine. You know, the concern, obviously, in pre-suit discovery is allowing fishing expeditions, because if we open the door too broadly, then everybody starts filing pre-suit discovery, and it creates mayhem. You obviously have an important fact, which is this individual took information from your company and sent it to her personal email address, or however she did it, which obviously raises concerns. But it seems to me that based on what you know, the appropriate course would be to pursue pre-suit discovery with her first to figure out what she did with that information, and did she use it in a way to disadvantage your client or to violate any sort of trade secret requirements, before you then go to her new employer and lob these discovery requests. So can you address that?
Yes, Your Honor. Good question. We have the case pending. This case involves both our claims against her and our claims against her employer. And part of the reason we're pursuing her employer is that they have separate counsel. Her employer, Ms. Crenshaw, put up her hands and said, my employer won't allow me to respond to these requests. We had a full oral argument before Chief Judge Nestor on the motion to dismiss. And so, Judge Bach, whether it's abuse of discretion or whether it's de novo, I submit that these 11 requests pass either standard with flying colors. These are 11 requests. As Judge Bergeron, you had indicated, this goes to the labyrinth of companies. Vora, if you look at their website, it's impossible to understand who is involved, where she was working at for sure, and the Catch-22, Polis, the Supreme Court, Ohio Supreme Court, talks about this Catch-22 issue, the Rule 11 issue. In the very first call, opposing counsel threatened us with the Rule 11 sanctions. We do not want to be in the position of suing the wrong entity, having more delay. We have respectfully sought this information for nearly 2 years. Our statute of limitations is running.
Have you filed any lawsuits at this point?
No, Your Honor, we have not, because Ms. Crenshaw is still in the case. The case is still pending before Judge Hathaway with Ms. Crenshaw. She has said we can't comply with all of this. She's pointed the finger to them, and Judge Hathaway did the right thing. We had a full hearing. We've had multiple arguments. This has been very expensive for my plaintiff. My client, this is a large defendant, large corporation. My client has been substantially harmed, irreparably harmed, financially and otherwise, in terms of personnel.
Wait. How has your client been harmed?
My client has been harmed because it's almost out of business, Your Honor.
Out of business, how? If you saw evidence that there was actual misappropriation of trade secrets and damage, then you have a basis to file a lawsuit.
This respectfully is an issue of a co-founder. We need to understand.
Well, but, I mean, the co-founder leaves. I mean, too bad.
The co-founder is recruited by Mr. Vora, by Ms.
Does she have a non-compete?
Yes, sir. Yes, Your Honor. She does have a non-compete, and part of,
Then why didn't you sue for a violation of the non-compete?
We don't have enough information to understand what the information, the story, part of the rules require us to try to get this information from her. We've worked with her counsel repeatedly, and the story is mere coincidence.
Well,
she just said this
go back to the statement.
Yes.
That your client's about out of business. What is the basis for that?
The basis for it, they've lost their co-founder, so it's a substantial harm. We need to tie causation.
That's not actionable.
It's not. That's why we need more information to tie it to some wrongdoer who's been recruited. The story is she just submitted this to her home personal email address. So literally, there's a story that this is the greatest coincidence in the world. I was recruited in December by this company, and I left, and then right after I left, right before I left and right after I left, I sent this to my home address just because I needed some tax return information. It includes tax return information, it includes her algorithm information. So the story is I never used it. So part of what we're seeking here, there's only 11 requests, is to see her drive, to see what she did with this information, to discount the story that it's merely a coincidence. And part of this, Judge Bergeron, is my client doesn't have the money to file a lawsuit and to have to go through this motion. We just heard the Supreme Court. This is a delay tactic, respectfully, because my client has a hard time affording this, respectfully, to pursue with this. And the goal is they'll drop it. We'll put up roadblocks. And that's why this is an issue that harms future plaintiffs, Your Honor. We are pursuing this not only for my client, but if this court were to say that there's no basis under the law that we cannot have a pre-suit discovery in these circumstances, then what are we going to do with other plaintiffs when you have large corporations attempting to hide the wrongdoing and put up legal roadblocks? So we need to be able to tie it to Vora. And Ms. Crenshaw, she's had some health issues, as I understand it, as well, Your Honor.
And she's no longer at the...
She was fired, is our understanding.
Okay.
Again, a coincidence, according to everything.
Well,
we've heard.
but then she's not harming you at this point. So
We don't know what she's doing at this point, and my client, after spending all this time and energy, wants to figure out the competitor.
I guess I'm so confused because, like, I've seen 1,000 non-compete cases where the person leaves, has taken information, is working ostensibly for a competitor, and there's an injunction filing. And the injunction may say simply, restrain her from using our confidential information in an appropriate manner. And it seems like you have enough to do that, or would have had enough to do that.
She was fired, Your Honor, and part of our requests go to the vendors to see what she's done with the information. We reached out, and her lawyer said, nothing to see here. This was a coincidence. And so that's part of why we submitted one of the main
But if
reasons.
you know what she sent, and if she sent information that was proprietary, you should be able to get that back.
We don't know. She submitted it, and we frankly gave it to them to say, here's what we're looking for, to try to cooperate in this process. We don't know all that she's taken, but we have enough. He said this is a fishing expedition. This is completely, you're going in the opposite direction from that. It's not a fishing expedition. We submitted it to him to say, look, show us what she did with this. We want to see the information. Did she send it to our vendors? We think she did, but we want to tie that together because part of the lawsuits are expensive. And for us to go down this path with a Supreme Court, a motion to dismiss, it's going to be further expensive. So that's part of why the whole purpose of this discovery is to allow us to sue the right parties. The case law says instead of filing and then trying to amend and going down that path, motion to dismiss, it's supposed to be efficient. And it would have been efficient, but for the way this has been.
Is discovery ever efficient?
Well, with 11 requests, Your Honor, good question, but I think 11 requests compared to what I seek in a lawsuit normally, we narrowly tailored this. And to your point, Judge Bergeron, Rule 16 exists. Judge Hathaway had a Rule 16. She was handling this the right way, and it was misrepresented to her that they were filing a motion for a protective order. They never offered any single request. We don't have a document, Judge. We don't have an interrogatory response. We don't even have objections. And Judge Hathaway had a Rule 16 conference.
Question to clarify the record.
Yes, sir.
Do you know what it was that was emailed to the personal email?
We do, and that is in the record, Your Honor. We know that part. We're not suggesting that's all, but it was algorithm information.
Do you know everything that was transferred?
We can't say at this point we do know everything that was transferred. No, Your Honor. That's part of why we're seeking this action against Ms. Crenshaw to get everything.
And why is it that you don't know everything that was transferred?
Well, because she did this surreptitiously. She did this, hard copy files. We have one email trail that we're able to figure out. This all happened in the process when she was being recruited by Vora and their many entities, including the chairman. This is a CEO. And so she was sending the information before and right after. before the time that, we knew that she was being recruited. So this was done surreptitiously. So we have information showing that she took stuff she wasn't allowed to take, shouldn't have taken.
And on that point, you know that she took that because you've got the emails that substantiate that. Why is that not enough to file a lawsuit against her for misappropriation of trade secrets?
We need to know what use she made of it from
But
a
she
competitive
takes it
nature.
Are they your trade secrets?
They are. They were
And she has
confidential
taken your trade
information.
secrets and is whatever she's doing with them, she's not using them consistent presumably with her employment agreement.
She, Your Honor, is saying she did nothing with them whatsoever. This was just, I was leaving, and this is the story. This is in the record from her lawyer, who's a local lawyer. She's had 2 or 3 lawyers, but they've represented that she's done nothing with it. We're not, and the story is they're not even competitors. The story from opposing counsel is that their clients don't even compete with us, that this is entirely innocent. And so we're taking a cautious approach, Your Honor, and I respectfully submit that this is to avoid a Rule 11 argument. This is part of why this discovery action is allowed to pursue, it's a narrow path between fishing expedition, and they want to catch us in catch-22s to say we either know too much or we don't know enough. Judge Bergeron, you're suggesting we know too much. Opposing counsel is saying it's a fishing expedition. We don't know. This is exactly the catch-22 that Ohio should not force plaintiffs to go through. We're not a code pleading state. We're not a situation where it's we have to walk on eggshells. This complaint clearly alleged necessary parties. So even if this legal discussion, this academic legal discussion suggesting that all the courts are different, they're not. We cited Rood, the 11th district that holds Rule 34 is applied just as we suggest it is. Judge Hathaway found this was necessary to identify the parties involved. And that's cannot be an abuse of discretion or even the wrong decision. It's the right decision. We haven't heard that it isn't. And I would submit, Your Honor, that if you look at the record, paragraphs 22 through 29, record 2, who encouraged this is Judge Hathaway's language after Judge Nestor, Chief Judge Nestor, had a full oral argument, and the cases were transferred consolidated. Who encouraged Ms. Crenshaw to violate her contract? This is why the discovery is allowed. Who encouraged Ms. Crenshaw to misappropriate the trade secret data at issue? Who within defendants and their many affiliated companies is unlawfully using that data? Who within defendants had or has knowledge of Ms. Crenshaw's unlawful activities? And who among defendants' clients and vendors with whom Ms. Crenshaw had contact also was given access to the data by defendants? This would show that they are competitors. This would show, disprove the claim that they're not even competitors. The court squarely found this discovery was relevant to identifying the potential parties.
You have about a minute left.
I'm sorry?
You have about a minute.
Oh, thank you, Judge. And Judge Bergeron, your question about, well, I think some of it is proper, some of it may be overbroad, that issue was never presented to the trial court. That's why Rule 16 exists. That's why discovery requires written responses, objections, meet and confer process. The law clerk was available and he actively participated in this. And I will cite a case that I was involved in, a federal case up in the Northern District of Ohio. We cited in our briefs, DiOrio versus TMI. The U.S. magistrate judge held in that case something that applies very truly here. Rule 16 exists. If the other side had merely informed the court of the discovery dispute, the court could have held a conference and said, all right, what's this about? The exact question you had, Judge Bergeron, maybe some of this is overbroad, but I think this is, we might have been able to resolve it. That never happened because the message was presented that we're going to respond, we're going to comply, no mention of a protective order. And from the beginning, they never liked the motion to dismiss decision. They could have filed for a motion for protective order along with the motion to dismiss. They didn't. They misled us and misled the court that they were complying, and then on the day in the late afternoon before their due date, their extended due date, they filed a motion for protective order, misleading everyone, forcing all this expensive briefing, for a plaintiff who is small, so small compared to their entity. But DiOrio said that the court could, for efficiency, could have ordered a one-page letter briefing, for example. This, respectfully, is a delay tactic, a tactic to try to force our clients out of business, to avoid them pursuing this. We have not received a single document. And where there's smoke, there's fire. They have not even agreed to produce anything. whatsoever. And so I submit that this is a case that cries out for Judge Hathaway to be affirmed. Chief Judge Nestor was involved in this. This case has been thoroughly litigated at the discovery. We're trying to do this for efficiently, but our fees, there's no abuse of discretion. There's no real argument that Judge Hathaway abused her discretion in that regard. And we submit that Polos, that opposing counsel relied on, the catch-22 that they're trying to literally catch my client in, is exactly why this cause of action is correctly found to exist here. If it doesn't exist in this case, it's hard to imagine a case where it would exist in. The whole argument, again, is a smoking gun, or is a fishing expedition.
Counsel, thank you for your arguments.
This is far from the fishing expedition. Thank you, Your Honor.
Thank you very much. A few things. First, with regard to the abuse of discretion standard or the de novo standard, this court, I believe in a decision that Your Honor wrote, the Richard case, found that a 12b6 tests the legal sufficiency of a complaint. And in 2021, the Supreme Court of Ohio in Johnson v. Abdullah found that questions of law are reviewed de novo. So it is a de novo standard on the first assignment of error. There is some dispute as to the second and third, but again, the court's disposition of the first assignment of error obviates the second and third. With regard to jurisdiction, the court did rule on Tiller's motion and denied it. And it did so for a variety of reasons, but something that Tiller has never acknowledged, that this court in Bright Futures explained that the denial of a 12b6 motion in a pre-suit context is not immediately appealable. There needs to be a subsequent order compelling the discovery. So until the trial court did that, we couldn't appeal. Your Honor, you posed the question as to whether or not the appropriate conduct or appropriate course of action would have been to serve first pre-suit discovery against Ms. Crenshaw, then against us. I believe that the appropriate course of action would have actually been to sue Ms. Crenshaw. As the court noted, they have alleged in unambiguous terms that she violated a non-compete and that she absconded with proprietary information. They now allege that they have been harmed by that. I don't know what that's based on, but they allege it, and I presumably have a good faith basis for doing so, which means that they can satisfy Rule 11, and they should have sued Ms. Crenshaw. If in the course of that discovery, they then determined that there was additional parties to be sued, then they can do that. But that does not allow them to serve pre-suit discovery on us because they don't need the discovery in order to file a complaint. They did not give us the proprietary information or any explanation as to what was actually taken. They indicated that that was in the record. It is not. What is in the record is a listing of emails.
It seems like that's sort of part of the heart of the issue.
What was taken?
Well, the fact that they don't know what was taken has created where we are today.
Well, that's
Because what they're trying to do is establish that your client is benefiting from trade secrets that were obtained violative of a non-compete or violative of, that were obtained unlawfully, basically.
I think that is what they're trying to do, Your Honor, to see if our client obtained it. But the problem is that they are in the best position to determine what was taken, not my client. And they provided us with a list of emails that Ms. Crenshaw sent to herself. If you look at that list, and that is in the record, the majority...
Does it identify what the attachments were? I mean, that's what we're talking about, right?
Yeah, they have the emails, Your Honor, that she sent herself. They're on her server. They're on their server, yeah.
But what I'm saying is, do they identify the attachments
No.
so that you are able to search for the attachments?
Absolutely not, Your Honor. And that's something that we asked for. How do we even look for this? We don't know what you say we have. They never say that. They speak in vagaries and say, well, they took proprietary information, and proprietary information could be anything from customer lists or proprietary trade secrets just generally. We have stated, there is sworn testimony in the record that we did not get their proprietary information.
That was unclear to me. What does the record establish as to what the potential trade secrets are or what the alleged trade secrets are that were taken?
Nothing, Your Honor. It doesn't establish what they were. And that's my point. They speak generally and say that trade secrets were taken, and then the only indication that they provide is a list of emails with just the subject matter.
So I think we can all agree just saying something's a trade secret doesn't make it a trade secret. There's more elements to than that.
Absolutely, Your Honor. And if you look at the subject matters of those emails, the overwhelming majority of them are clearly personal emails. They pertain to like medical insurance, for, Ms. Crenshaw's husband is disabled, I believe, so she was emailing herself documents that pertain to his care and the insurance that she obtained while she's there, and then the transfer of that insurance to a subsequent employer. It has nothing to do with the operation of Tiller at all. And that's apparent from the face of the emails that they've provided to us, but that's as much transparency as we
Would you
have.
address their position that Mrs. Crenshaw has been, and I'm just going to say it, uncooperative? Because of that, the information that normally would have been obtained that would allow them to establish whether there's any culpability of your client or not has not been able to be flushed out, and that they have no other course of action than what they're currently trying to do with your client. How would you address that?
Sure. Thank you, Your Honor. So the answer is, in the first point, I don't believe that Ms. Crenshaw has been uncooperative. She filed a motion to dismiss. It was denied, and rather than pursuing the course that we did,
But let's assume she was.
she was uncooperative.
Yeah, let's assume that what their argument is factually correct.
Well, I still don't think that would actually allow them to seek the information that they are seeking here, because it still goes outside the scope of both mechanisms that are
But
at
I
play.
think going back to like my question earlier, if they try to get it with her and they can't get it with her because she's uncooperative or you guys tell her not to do it or whatever, then it seems like they have to set their sights on you at that point.
Well, I think, Your Honor, when we speak about this, I think we need to be precise about what it is that they're seeking, right? So under the Rule 34D, it has to be the identity of a known party. And she either can provide that information or she can't. And what she told them, as Mr. McIntyre told you, is she didn't give it to anybody. That's not being uncooperative. That's providing an answer, and they just don't like it. So now they're coming to another well to try to find a different answer. And we told them, we didn't get it. That's there in sworn affidavit testimony. But they don't like it. So they want to they want to do a forensic review of our company's computers, which is something they wouldn't be entitled to even if they sued us, because the obligation is on the responding party to do an appropriate search in the first instance, and then only if there's evidence that this search wasn't appropriate do you then turn the actual device over for a forensic analysis. So they're putting the cart not only beyond the horse, but like a mile past the horse. They're trying to get information that they wouldn't be entitled to even in an actual lawsuit. Does that answer your question?
It does.
Okay.
Counsel, I'll give you 30 seconds to wrap up.
Thank you very much, Your Honor. This is how I'll close. Counsel indicated that Rood was one of the cases. He said we cited a bunch of cases out there that support our position. Rood from the 11th Circuit was one. I'd like to read from Rood very quickly. In addressing Benner, the case that they hang their hat on, the court says that Benner found that Rule 34 permits a party, Benner found that Rule 34 allows a party to determine if it had a valid cause of action against a known adverse party. It then immediately follows that and says, we do not interpret the civil rule that broadly. It cuts against Benner. It expressly rejects Benner and then proceeds to go on and explain that what Benner said and what the trial court said is wrong. So the authority that counsel is standing here citing to you as the reason you should affirm is actually the reason you should sustain our assignment of error.
Thank you,
It
counsel.
does not say it. Thank you very much, Your
Thank
Honor. Thank you.
Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. We wish you a wonderful afternoon. Good morning. Good morning, Attorney Thomas. You can come forward.
Thank you, Your Honor.
Would you like to reserve time?
Your Honor, I'd like to reserve 10 minutes for rebuttal.
Okay. Whenever you're ready. Whenever you're ready.
The trial court erred by granting summary judgment on a soundbite. Like all sound bites, the statement taken in isolation and without context. The specific context was a statement on cross-examination in the deposition of plaintiff's expert. The question, you don't consider radiology or radiologic technology within your area of expertise, fair enough? Answer, no, I'm an ENT doctor. On the basis of that, UC Health has stated, quote, Young sets forth no evidence that Dr. Green understands the standard of care for an MRI technologist.
I don't think that's, I mean, I appreciate they've made that argument, but I think part of the issue was more substantive in terms of assuming he does have the correct expertise, and he clearly is an ENT, to evaluate what was the failure in the standard of care, what was the breach that caused your client's harm. And on that issue, Dr. Green was very equivocal in his deposition and didn't specifically identify what the nurse did that was inappropriate.
I respect the question. I believe it's a factual issue. It's certainly not the basis for the trial court's decision, and it was not the basis for UC Health's argument at any point.
So let me make sure that I'm understanding what you're saying. So the trial court, in its decision granting summary judgment, specifically found that the plaintiff is unable to sustain his burden of proof regarding the standard of care, correct?
Yes, Your Honor.
Okay, so that's one of three things that that the plaintiff would have to prove. It would have to prove what the standard of care is, it would have to prove a breach of the standard of care by defendant, and then it would have to prove that that breach was the proximate cause of the injuries, correct?
Yes, Your Honor.
So if I'm understanding you, what you're saying is that because the trial court only looked at the standard of care and found that your client could not prove the standard of care, that we only need to concern ourselves with the standard of care rather than breach and proximate cause.
Absolutely, Your Honor. I mean, if the court wanted to look at that, I'm happy to address it, but I'd like an opportunity to brief it because their motion to the trial court did not address those issues. It was all, we just took the video deposition of the plaintiff's expert and it's defective in this regard, the Adams v. Durrani issue, completely ignoring the testimony. And I would submit that
Where is his testimony of what the standard of care was for, I forget her name, the nurse who applied the earplug?
Ms. Waits, Your Honor. At docket 60, at page 32, line 18 to 23, question, is adequately ensuring that the patient in the MRI examination has adequate hearing protection part of the standard of care in conducting an MRI? Answer, yes, and that is published by the professional organizations of radiologists and the radiology technologists. He goes even in further in his discovery deposition, which also would be before the court on summary judgment, stating at docket 43, page 66, the American College of Radiology Manual on MRI safety, just to reiterate, states that facilities provide instruction on proper placement of hearing protection to all persons receiving them and verify fit and function of the hearing protection prior to the MRI examination. Close quote. That's the standard. It's completely ignored by UC Health.
But if you look at later in his deposition, it says, would you agree that Ms. Waits did place the earplugs in the ears? Yes. You don't have a criticism of her for doing that? No. And that's an appropriate course for her to take? Yes. So she put them in his ears. Correct. That was the appropriate standard of care.
It was the appropriate thing to do. What was not done was to adequately ensure fit and function such that the hearing protection was adequate.
And where does Dr. Green say that?
Your Honor, again, I apologize that I'm not able to quote that issue, which is, I submit, is a factual issue, but I'm convinced that the deposition is rife with that.
Well,
Or let me just answer Judge Bergeron's question, forgive me. Docket 60, page 31 and 32. Question, and is it your opinion to a reasonable degree of medical certainty that this hearing loss that Mr. Young experienced was a direct and proximate result of not having his ears properly protected during the MRI examination? Answer, yes, sir, it is. And I think it's best.
But I think like that's almost like a res ipsa type argument. Like what I'm trying to understand is you're saying that the ears weren't protected. Dr. Green is acknowledging that she followed the proper protocol for protecting the ears. So my question is, what happened? What specifically did she fail to do that leads to this conclusion that you just read?
The thing that we must remember is that Ms. Waits is not testifying from memory. She's testifying, this is my habit. She remembers Dr. Bill Young's MRI only insofar that the significant feature for her, there was something called an artifact which required an adjustment during the middle of the process. She remembered that as being a unique feature. But with regard to the fitment of the earplugs, she's testifying from this is what I do, not this is exactly what I did because I remember doing it. That testimony would be difficult to believe in those circumstances. But the res ipsa question is a legitimate one. The effect of the MRI jackhammer sound on Bill Young was immediate and dramatic. He wanted to talk about it with someone at the desk immediately after the exam. He was unable to find anybody. He went to his doctor immediately following that, the next day, I believe. Tests were taken there, and continued to pursue remedial efforts to the extent that he was able. But it's that character of the evidence when we're testifying about this is what I normally do, I think precludes any expert.
She's saying this is what I normally do. I don't have any independent recollection of that procedure. And then your client isn't disputing that. He's not saying, no, that's not what she did. I never got the earplugs. So we have two people who maybe don't have perfect recall of that, but you're having to establish as part of your case that she fell below the standard of care. And I realize the difficulties of that in this type of scenario, but that's where your expert needs to connect those dots.
Well, Your Honor, I believe the expert has connected those dots on the basis of the circumstantial evidence that we have.
I mean, isn't ultimately what you're saying is what the expert is saying is, had the proper protection been done, your client would not have a hearing loss.
Precisely,
That's
Your Honor.
basically
Precisely, Your Honor.
putting it simply, right? So he's saying.
Better than I did.
Yeah. Okay. So, so I think that's, and then you're ultimately saying this is an issue of the fact that should have gone to the trier of fact.
Exactly.
So that the nurse is saying, this is what I did, and your client is saying, this is what I experienced. And then the trier of fact would have to determine whether there was any deficiency that led to your client experiencing what they experienced.
Exactly, Your Honor.
so really, so Dr. Green's testimony, there was no possible way for him to know whether if he indeed did establish the standard of care. There was no way for him to know whether it was breached for sure. That was really based on inference, correct?
Inference based on the circumstantial evidence.
Right.
Precisely, Your Honor.
Right, because him not being in the room and Ms. Waits not being able to recall specifically what happened, there was no way for anybody to have been able to know specifically what happened, correct?
Exactly, Your Honor.
Okay, thank you.
If there are any other further questions, I'll wait till rebuttal.
Okay. I'll
Thank you,
reserve the
Judge.
10 minutes. Thank you. And you did it perfectly on 5. Good morning.
Morning. Thank you all very much. Just to reiterate, Allison Knurr here on behalf of defendants, appellees, University of Cincinnati Medical Center and UC Health LLC. What Mr. Thomas said initially was a soundbite is not a soundbite. It's a very clear and fundamental issue for his case, which is his witness specifically testified, I am not here to testify what the standard of care is for an MRI technologist.
Ms. Knurr, wouldn't Dr. Green's expertise overlap a bit? Because so he's not testifying about the, how to do the MRI. He's not testifying about the results. He's not testifying about any particular procedures. The only thing he's testifying about is that when you have a procedure that is loud, be it an MRI or be it something else, that there needs to be ear protection, and the ear protection needs to be properly fitted.
And respectfully, Your Honor, when it comes to certain causation issues, perhaps he would be qualified on causation, but when it comes to standard of care, the law is very clear that when you're testifying to specific deviations or act or omissions, you have to understand what the standard of care is for that specific practitioner. And so when it comes to here, how Ms. Waits properly, her process for properly inserting the earplugs, for verifying their fit and function.
But how could an ENT not be qualified to testify about ear protection, regardless of what the sound is? Like, it's loud sound, I therefore know that you need to protect the ears, and here's the ways to protect the ears. Like, how could an ENT not be qualified to testify?
Well, respectfully, Your Honor, what I would say is, as is plaintiff's burden to demonstrate that, where's the testimony demonstrating that he's qualified? There's simply not any. He does not give any, he could have said, when I said, are you giving any opinions as to what the standard of care is for the MRI technologist? He could have said, I understand how the MRI technologist is to place earplugs because I train people to do that. I know the standard for
Isn't that the
that.
heart of the issue? Because it seems to me that that's a very broad question, not testifying on the standard of care of the radiologist. Well, I don't know what we're talking about there. It could be about a million things about the radiologist. But if he said specifically he is able to discuss the ear protection part of it, that's exactly what's at issue here.
Well, the question is not ear protection, it's whether or not someone did an act or omission that deviated from the standard of care. So simply protecting or not protecting, whether the ears are fully protected or not protected, it goes more to, again, causation questions. The standard of care is, did Ms. Waits commit an act or omission that deviated from the standard? And there's no testimony whatsoever on that.
It
And
seems like there's an overlay here, because this isn't a case in which no earplugs were put in. And then
Correct.
that would be very clear. The standard of care, you put earplugs, they didn't put in earplugs. Okay? This is a case in which earplugs were put in, and so the issue becomes, okay, so, now Young is saying, well, I've had hearing loss, and I realized immediately after that there was something wrong. Seems like there's an overlay there.
Well, I mean, what I would say here, again, and I hate to go back to this, but it's plaintiff's burden to establish standard of care. And so, nowhere in either of the depositions does
Why
Dr.
isn't it
Green...
enough for him for the standard of care to be established by saying earplugs are needed?
Well, what I would say is, I don't necessarily know that he goes that far, but again, he has to understand the standard of care for the
Or ear
specialty.
protection is needed?
But even if that's what he said, he says she got ear protection. So he does not establish any deviation from the alleged standard he sets. He says all the evidence
What if
demonstrates
it comes down to what he's saying is proper ear protection is needed?
And he actually says the types of earplugs, the brand that she used, that's a good brand too. And in fact, he says at some point, it's appropriate for Miss Waits to rely on Mr. Young to tell her, do these fit or do these not fit. And there was a point in the MRI where Mr. Young had to be taken out for some artifact on the images and rescanned. And at that point, even Dr. Green says, yeah, that would have been a good opportunity for him to tell Miss Waits if the earplugs were not properly seated. So
But
to
aren't
the
all those things that should be going to the trier of fact?
They are not things that should be going to the trier of fact because under Ohio law, the expert you're required to have an expert to testify that there was a deviation from the standard of care and that they are familiar with the standard of care. And again, here, neither one of those things is accomplished. On the first point again, Adams versus Durrani is a recent case here from the First District that looks at these issues and says very specifically, you have to demonstrate with expert testimony in advance of trial that you have an overlapping standard of care, that it's a similar standard of care between your specialty and the specialty at issue. And again, there's no testimony here whatsoever that the standard of care for a ENT doc or an otolaryngologist is at all similar to an MRI technologist. There's just simply not any evidence on record of that, which is their burden to meet.
I guess I'm confused, who would be the expert, if not an ENT doc, to come in and testify about the propriety of ear protection? Who would that be?
Sure. So we actually offered a neuroradiologist, Dr. Jerome Barakos, and Dr. Barakos testifies that as part of, he also does that, places earplugs. He trains MRI technologists. He supervises MRI technologists. So he's familiar with how they are trained to conduct their job, how they are trained to verify fit and function and place the earplugs. He does that training himself. And so that's the type of testimony that you would look for.
So he's testifying that you need earplugs in these situations. Here's how you do that. But that's the same thing that Dr. Green's testifying about, and they obviously come at it from different perspectives, but it's the same underlying expertise, it seems like.
And respectfully, Your Honor, it's not the same underlying expertise because Ohio law is very clear that the different specialties are all held to their own standard. And the requirement, again, is very simple, that you have to have a physician or expert testimony to simply say, I am familiar with the standard for the specialty at issue, and it's an overlapping specialty to my standard of care.
So would it be a different standard for ear protection in different areas? So for example, if you had a different procedure that there was going to be a lot of loud noise, how would it be different?
Well, I'm sure, Your Honor, and again, because there's, that's not anything of evidence in the record, I may be speculating somewhat, but depending on your specialty, the machines may be different degrees of loudness. There may be different, some patients are allowed to insert them themselves. There may be different requirements to check with the patient, questions you're supposed to ask them, things like that. For example,
if there's a different degree of loudness,
yes.
And this procedure versus a different procedure, wouldn't Dr. Green's specialty encompass all of that?
Well, and not really, and here's another point too. Here, there's also the issue of, depending on what you're scanning, different types of ear protection are used. Because of Mr. Young's body habitus and the area he had scanning, a lot of times they'll have extra coils that go over your head, right? Additional hearing protection. You could not do this in this specific instance because of the nature of the scan and because of Mr. Young's habitus. That would be something an ENT doc would not have any familiarity with. Because again, they don't do MRI scans, and frankly, it's not even clear from Dr. Green's testimony that he uses earplugs on patients or ever fits them, or verifies the fit with them. And again, the issue here is not whether or not ear protection was provided at all, or whether or not the brand of ear protection was the correct brand. It was whether or not Ms. Waits did some sort of act or omission that was inappropriate, and none has been identified. We asked them in the trial court initially, upon our renewed summary judgment, tell me what Ms. Waits did wrong, and they've never been able to point to anything. And that's a fundamental requirement to proceed.
Could anyone have pointed to what she did wrong, if indeed she did?
Well,
Because the only two people that were there were her and Mr. Young.
Correct, and neither of them have offered any, I mean, that's true with any surgery, respectfully, Your Honor. The only people that are ever in the room for the surgery are the people participating, the individuals having the procedure done on them, and the medical records. And in all those cases, people can adduce evidence that says, they cut in the wrong place, they didn't react quickly enough to a complication.
So isn't
None of that was done
exactly
here.
what this is about? The adduced evidence is that the ear protection may not have been properly placed in the ear to properly protect the ear canal.
And it's, again, I think that's results-oriented, right? Where, again, the question under Ohio law is what is the act or omission? So what is the thing Ms. Waits did or failed to do that is not compatible with the standard of care? And so, whether it's, she didn't.
But as I understood, no one's contesting the quality of the device itself or the appropriateness of the device itself.
Yes, that's correct. That's correct. So, and again, so the question is, did Ms. Waits do or fail to do something she was supposed to do? And there's been no evidence on that here.
I think that counsel would argue that his client's hearing loss is the evidence.
Well, and again, there are complications from medical procedures all the time. Just because there is a complication from a procedure does not mean that anything was done appropriately or inappropriately. It's not a strict liability standard here. You have to identify an actual deviation. Additionally, here, Mr. Young had very extensive pre-existing hearing loss and also other medical issues when it comes to medical anxiety and various types of hypochondria that
That seems to me like what you just described would be questions for the jury.
if they were able to meet their burden on standard of care and deviation therefrom, then I would agree. But Judge Zayas brought up the subsequent hearing loss, and so I was just presenting some alternative explanations for why that would exist. I don't think the fact that he did or did not have hearing loss, frankly, is relevant to an analysis of whether or not there was a deviation from the standard of care, or whether or not the expert is able to establish in the first instance that he's familiar with the standard of care. These are very, fundamental burdens that plaintiffs have to meet initially before they can even proceed to questions such as causation or to get an issue of fact before the jury.
Thank you.
Thank you.
Attorney Thomas, it seems like the challenge in this case is when we're talking about a medical procedure, we're usually talking about a procedure in which something is being medically addressed, like a surgery. Well, here we're talking about a procedure that is used for analysis that is not curative of its nature. Do you understand what I'm saying?
Diagnostic, exactly,
Yeah.
Judge.
So it seems like that's sort of the challenge here, is that we're applying all of these principles that usually apply to procedures that are to address or curative and so on, and here we're applying it to a situation in which it is something that was used to be diagnostic.
That's a very apt point, and it helps illustrate why trying to fit that into the Adams-Durrani box is inappropriate, inasmuch as we've got nothing, to follow your line of thought there, there's nothing whatsoever in the case about the idea that Mr. Young suffered an injury related to the improper sequencing or the improper scans or the use of the scans or the being exposed to the energy of that powerful device. It's all about the sound. It's the jackhammer. It's the military aircraft
So
taking
let's
off.
say we agree with you, and this goes back to trial, and you're in front of the jury, a closing argument on this record. What do you tell the jury that Ms. Waits did wrong?
She did not adequately ensure that he had hearing protection
And your basis for that is,
because he immediately sustained a dramatic loss of hearing. There was I don't even know how to frame it, the idea of, then Ms. Kinner remarked about there's other possible explanations as consequences of this procedure. There's no consequence of the MRI that explains the hearing loss other than the inadequacy of the hearing protection provided. The pre-existing situations, obviously, those go to the jury, whether there's issues there. Judge Bergeron, you made a comment about who would be qualified if not an ENT. I think Ms. Waits would agree with you. We asked her some questions about just the basic sounds, the audible levels of this 3 Tesla machine, which is the loudest that they make. And she said that she couldn't answer those questions explaining, I'm not an ENT. She picked the discipline that would address those questions. That's at docket 42 at page 55. I think even if the situation isn't on all fours with this, dealing with a diagnostic procedure that the true core of which did not cause the injury, if we go back to the Adams-Durrani analysis, in that case, as the court well remembers, we had a neuroradiologist who was allowed to, among other things, talk about whether surgery was needed, even though he was not qualified to perform the surgery, and was also allowed to talk about whether the patient could have given informed consent, because informed consent is something that cuts across all medical disciplines. And that resonated with me when I was hearing the court's questions about an overlay, or there's overlap. That's what we're talking about. When we're dealing with sound, regardless of how it's created, I don't care if it's an MRI or a CAT scan, which is slightly less loud, or whatever procedure that creates that type of danger to hearing, there is a standard of care to protect the hearing against that. And that's exactly what we have here. If we're going to allow radiologists to talk about standard of care, Dr. Green, whose ENT credentials are pretty off the chart, is certainly competent to aid the jury in understanding that rather simple point. What other questions does the court have? I know you've got another case, so I won't belabor it.
Okay.
Thank you.
You still have some time left of your 10 minutes. All right, well, thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. Have a wonderful Tuesday afternoon. Good morning.
If I could reserve 3 minutes. Okay. May it please the court, Ms. Ferris. Mr. Arnold stands convicted of the offense of making false alarms. We levied 2 challenges against that conviction on appeal. So first, just some quick background. The offense at hand is prescribed by 2917.32, which provides in pertinent part that no person shall report to any law enforcement agency an alleged offense or incident, knowing that that did not occur. So Mr. Arnold challenges the evidence supporting that he was the person on the other end of the Terrence phone call, the call that was made in the early morning hours of January 6th.
And just for clarity, the complaint didn't actually state, it said at 2917.32, didn't state Section 3, but if I recall, had the language of Section 3.
It did, you're correct, Your Honor. No mention, but it was the exact language tracked, yes.
Okay.
Well, and let me ask you a question about that, because we had a case a while back that involved a similar situation, not in the same statute, but there was a failure to identify the subsection
Yeah.
in the complaint, and ultimately, the way that issue came up was the defendant challenged essentially the amendment of the complaint at that point in time, and then we, analyzed it that way. And I don't see that type of argument here, and I'm wondering, is that something that is necessary here when we don't have precision in which subsection it is to effectively challenge it?
So our brief doesn't expressly raise it simply because it wasn't raised below. However, in arguing other cases, I know that this court is empowered to sua sponte decide any issue that is implicit or tied to any issues that were presented. So if this court will want to,
Briefing,
excuse me?
with briefing.
Yes. So if this court would want to forge ground on that issue, it could move ahead. But we didn't raise it because it wasn't preserved, and there's no objection.
But was there a pronouncement of because sua sponte under Criminal Rule 7, the bench can change it, and certainly the state can change.
Yeah.
Was there a pronouncement from the court to change it?
No. No, so again, it's not something that I felt like.
And did the court ever specify, I don't recall it from the transcript of her decision, did the court specify which subsection he was actually convicted under?
Not that I recall, no.
Was there argument from the state that paralleled the language of any subsection?
I would have to review their closing argument for that. That would be the place I would say that we should look, and I don't know off the top of my head. I apologize. That would be the place to look, though. So I apologize for not knowing the
That's
answer
okay.
off the top of my head. But
I know you came ready to argue your brief.
yes,
We
and
understand.
usually I bring my transcript
We
notes.
understand.
I bring the transcript notes, and I didn't this time because it's a simple case.
Yeah.
It's just
Yeah.
So
Well, it's a bit of a transcript, too.
What's that?
It is a bit of a transcript,
A little, yeah.
yeah.
So the only, the chief issue, the chief thing we take issue with is the trial court's finding, when it did find Mr. Arnold guilty, was, quote, "The only thing the state didn't prove was whether or not Mr. Arnold was the person on tape making the report," end quote. So rather, the court grounded its finding in this idea that Mr. Arnold caused the call to be made. And the threshold issue, and I think what is the meatier issue, is that and there's not a lot of case law on this statute at all. So this court gets to sort of forge new ground if it so chooses. That causing the call versus making the call is, our position is insufficient for the actus reus. So under the A3 subsection, and we utilize a straight statutory construction.
Well, the language of the statute is that report to any law enforcement agency an alleged offense.
Correct,
So it doesn't say cause to be reported,
correct.
or was part of the reporting, or
Right.
it says report
Yes.
to any law enforcement agency an alleged offense.
And therein lies the crux of our argument that if you we don't believe you need to go into the statutory, the tools in the toolbox for ambiguity, because this is not ambiguous. So you look at, we all know, the plain meaning, ordinary language first. Subsections 1, 3, and 4 are all that active voice, that direct active connection. Only subsection 2, knowingly caused to be transmitted. That is the only subsection that uses passive voice. So we are,
And I guess I'm just looking at the statute here too, and it says, picking up on Judge Dice's question, report to any law enforcement agency. Does that mean, in your view, you have to report directly to the police or the fire department? Or can you use the intermediary of 911, because the second 911 says, for any agency dealing with emergencies.
That is interesting, because what I pondered and didn't think of how to incorporate it into the assignment of error is, I had written down revised code 128.32. So oddly, it's not in the criminal code, but I had seen that statute, its subsection E, referred to in another criminal case for the offense of misuse of the 911 system, which is only in M4. So I don't know why, if that is its own separate offense, why that wasn't used in this was. I don't know. That is an interesting issue, whether it has to be direct or if 911 is a proper intermediary, because it does invoke emergency services, so I'm not sure. But that's interesting. So, like I said, I did a quick search just again yesterday for this very statute, and the case law is woefully shy. In fact, for the A4 subsection, because I was trying to contemplate what that would even involve, what actus reus, there are no cases on it. The most of the cases are the A3 subsection. And again, if we use the usual maxims, plain language, ordinary meaning, we presume that the legislature chose the words that they chose on purpose and not by accident. This utilization of the active voice for almost the entire statute, and only the causate knowingly cause for that one sub 2, cause to be transmitted. And the funny thing is, again, when you search even that sub 2, I found one case in Lexis, just one. So that is not charged, it must not be charged much, it must not be appealed much, maybe not convicted much. Again, the 3 is the crux of all the cases, and we submit, this is actually a very simple case that when you go back to the trial court's finding, we don't know he was on the other end of that phone. That should have been the end of it. That is the sufficiency issue. So that's the statutory construction argument. If there are no other questions, I can quickly touch upon sufficiency and weight. It kind of is sufficiency, but the only other thing that if this court does decide that causing a report to be made is enough under the A3 subsection, that the state did not fulfill their burden because really, again, no one is saying that's him or that he's responsible for it. There was circumstantial evidence tying the number to, I think through RCIC, saying that it was Mr. Arnold's number at one time. But then no evidence, this Ms. Gibson, the mother of his child, could have easily been called to say, yep, that's his number, yep, that's his voice. It wasn't done. So this, the officer they called who did this investigation said that he linked the number to my client, and then it was registered to this Mike Lowry who, anecdotally, he knew that was a character in a movie. We submit that's not enough. You can jump on Google and Google Mike Lowry from Kansas and see if some names pop up and see what happens, He didn't do that. So just quickly on that, we would submit that the circumstantial evidence, even if this court says causing a report to be made, is enough to meet the standard, that the evidence does not support that Mr. Arnold did make that call or cause it to be made. So we would ask you to reverse and either discharge or remand for new trial. Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, my name's Danielle Ferris. I represent the city. This is my first time here, so I'm a little nervous.
That's okay. Thank you for being here. We all have a first time.
The evidence presented in this trial under both case numbers establishes that on 2 occasions within 12 days of each other, a woman called the police to report a domestic situation involving Hassan Arnold, and within the hour on both occasions, another call was made to the police by an individual with a male voice associated with that same phone number, and in both times he reported shooting crimes. So that.
And maybe if I could just kind of skip forward to the crux of the issue that the defense was raising. What is the state's position on which subsection he was actually convicted of?
Well, first and foremost, I think that issue was waived when it wasn't raised at the trial court level, because it would have been quickly amended by the trial attorney with a 7D motion, and that's the time and the place to do that. I believe, per our brief, that we satisfied beyond a reasonable doubt under all 3, sections 1, 2, and 3. I think there is sufficient evidence because we have a male voice We have the association of the phone number with him in RCIC and RMS. We have him described or mentioned in the earlier phone calls.
Right, but the court specifically found that that the state did not establish that he was the one making the call. So I feel like that's, if the court had not said that, I think this is a totally different case. But the court is making a factual finding on a failure of the state to prove one aspect. And so I think what I'm trying to think about is how do I apply that to this statutory framework?
I appreciate that point. I do think that distinction was wrapped up in some language about whether or not he was framed. And so I think she was talking about how sure she is that he did it, because she goes on to say that it's hard to believe that somebody would frame someone this intensely for a misdemeanor. And so I believe that if he wasn't the individual on the phone, that still satisfies the third subsection, that he made the report, because I think that the passive language argument that she discussed, I disagree. I think that causing another person to have made that call and being right there would have satisfied the making actus reus. But I do understand that the language that the judge used was closer to that of Section 2 of that. And so had the issue been raised at trial, our office would have amended it to Section 2, I believe, based on the way that it was.
But was there any argument at trial in terms of establishing proof that Section 2 was the one that the state was proceeding under rather than Section 3?
There was not. The argument focused on all of the circumstances which Judge commented would be too many coincidences to believe, that this male voice is calling on multiple occasions within an hour of the domestic relations issue. Judge was very confident that this was an action taken by the defendant to cause the police to be distracted from what was actually occurring. And the dicta did go a little bit further in that when she was talking about how unlikely it is that somebody would frame someone for a misdemeanor. But I agree that the complaint
Crazy
and the
things
language
happen.
of Ms. Barnett specifically goes mostly to Section 3, but it does satisfy Section 2 as well.
Well, on that, so Section 2 and Section 3, so if Section 3 could also be report or cause, is that what I'm understanding you're saying?
I think it can be, yes.
So what is the purpose of Section 2 then?
Section 2 focuses on fire a little bit. I think there are other emergencies built into it.
So is 3 though, because it's alleged offense or other incident within its concern.
Yes, so the way that I had read Section 2 is if you're someplace and you shout fire and other people call 911. His actions in this case are much more direct than that, and that was the court's point. So he's not shouting emergencies and bystanders are overhearing him. Either he or a male at his direction are making these phone calls, which is a much more active make action than somebody panicking or exclaiming and causing pedestrians. So the cause language there, I think, goes to an actus reus that's even more passive than what Judge Trotter Bratton felt the defendant was doing in this case.
Thank you.
Just to touch on the credibility of the evidence, these were 911 call takers and CAD reports. The credibility on a manifest weight challenge is essentially not at issue. With that, the state will rest, unless you have any further questions.
Thank you.
Okay. Just a couple of brief points. If the panel so chooses, I would be happy to brief the additional issue that implicates this court's case about the missing, specifying the subsection. Should just throw that out there. I would love to chomp it at the bit now to get to it. We don't concede that counsel respectfully had opened with citing the evidence in both cases, and he was acquitted on the one. So these were, it was weird, like, municipal court is a huge case docket, trying to be efficient. These were tried one after the other, but they weren't joined. So didn't raise a stink about it because counsel didn't, even though the judge did at the end, and her findings seemed to combine the facts of both cases. So I didn't want to assign that as error, but we're not conceding that that's even appropriate. I only relayed those facts in my brief because of the court's eventual finding, and I felt it was relevant background. And then the last, I think most important point is, again, respectfully, when the state says that sub 3 should be read to say report or cause. It is black letter law. You do not add words to a statute. So we say that that is absolutely inappropriate to throw cause in there when the legislature didn't do it and only chose to put that in sub 2.
Would you please address your opposing counsel's argument about this was waived because it wasn't raised below?
Which argument?
The argument about the subsection. So when in her, when she was pronouncing her findings, she talked about it being that, not knowing who it was that actually, who the voice was, but for sure, she believed that Mr. Arnold caused. And your opposing counsel said that since there was no objection to that, it was waived. Can you address that, please?
I think that we can't then transpose that to a brand-new subsection of the statute when I think I quoted in my brief and I underlined the lines in the form complaint. So under due process, the complaint serves as the notice to the accused of the thing that could deprive him of his liberty. And in this, the complaint exactly tracked the language of A3. So the idea is that that is the only language he was on due process notice of that they could go forward unless they amended that. So regardless of what the judge...
And at trial, was there any effort by anyone to argue under the A2 versus A3?
Not that I recall. I recall reading this with that framework from the complaint in mind, going, it looks like that's what they're trying to go to, and never amending it or deviating. So even if the judge at the end sort of loosely made findings or whatever, I think everyone was laboring under the impression that that complaint gave that notice and that's the subsection we were using. Because it did track it exactly, the A3. So, and then regardless, if there's any implication, respectfully from counsel, that the overall argument was waived, our arguments, the assignment of error is sufficiency and weight. So this is all going to the sufficiency of the evidence, and then it's a legal issue, the statutory construction thing. So we would say that part is definitely not waived. Is there any no further questions? We would ask to reverse and discharge or remand for new trial.
All right, thank you.
Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission, and we will issue a timely decision. Have a wonderful afternoon.